Welcome back. We are ready to proceed with our final case for the morning. We have Judge Sawaya on my right and Judge Berger on my left joining us this morning for this final case of SCHERER Construction versus the Scott Partnership. So, counsel, when you're ready, you may proceed.
Good morning, Your Honors. Mark Babcock on behalf of the appellant, SCHERER Construction and Engineering of Central Florida Incorporated. May it please the court. Your Honors, I believe some context regarding this case is required to kind of explain the circumstances under which we are appealing the ruling of the underlying court, entering final judgment on behalf of the Scott Partnership Architecture and taxing attorneys' fees and costs pursuant to 57041 and statute 768.79. In this case, Your Honors, we've got a massive construction defect case. My client served as somewhat of a pseudo general contractor to finish the last of 4 buildings in Orlando that were going up. There was an initial general contractor, Harbco Construction, started the project. We came in on behalf of the owner's representative to finish their work. There were some issues getting it done. So we come in, we're a named defendant. We file third-party complaints against several subcontractors, including the Scott Partnership Architecture. Over 30 subcontractors we've got named third-party complaints. We litigate this case over 2 to 3 years, complex litigation. Over the course of litigation, several of the subcontractors settle out, come to agreements. We settle out with them. They're dismissed. We reach a final settlement agreement with the plaintiffs in this case, and there are 2 remaining third-party defendants, Unicorp National Developments and the Scott Partnership. We have identical claims of contribution and common law indemnification filed against both parties. The underlying court...
What about the offer of judgment issue? Why don't you just get right to that?
Sure, Your Honor, and I'm glad you brought that up. We have cited in our supplemental authority, Judge, the case of MX Investment v. Crawford. There are 2 arguments under which we feel the offer of judgment is not triggered. First and foremost, the Investments v. Crawford case talks about the proposition that a filing of a notice of voluntary dismissal without prejudice cannot trigger attorney's fees and costs pursuant to statute 768.79.
Yeah, but what about the contribution claim on which they got a summary judgment?
Judge, I would urge the court that they did not prevail on all claims. Their proposal for settlement called for winning on contribution and common law indemnification.
Is that your strongest argument, that all claims part of the offer of judgment? Is that it?
That's our argument, Judge, but also...
Why wouldn't the cost be appropriate? Let's just, for purposes of argument only, say that, well, okay, well, as to the one claim, fees should not have been awarded. Why wouldn't costs be appropriate?
In our opinion, Judge, they're not the prevailing party. When we filed our notice of voluntary dismissal without prejudice, there was still a common law indemnification claim pending. At that point, they did not prevail on all counts, which is required under the proposal for settlement. If you look at the strict language.
Under the rule for assessment of costs.
Yeah, that's what I'm talking about.
Forget the offer of judgment.
Costs
Why
only.
aren't they just entitled to costs?
Because we don't feel that they were the prevailing party overall, and the cases that we cited to.
How much did you get and how much did they, from them? You got 0, didn't you?
That's correct, Judge.
Money, you got 0.
That's correct.
That sounds like they prevailed.
Well, under these circumstances, and that's why I tried to explain the context of this litigation, as I think it's very pertinent to, it looks that way, but what in essence happens is the Scott Partnership is the last man standing. Their motion for summary judgment on common law indemnification was deferred by the court. Unicorp actually prevailed on their summary judgment. If you look at TSPA's motion, it's not a motion for summary judgment on the issues of contribution and common law indemnification. It's really a motion to strike based on expert testimony, and that's why the court deferred ruling. But we don't feel under these circumstances, because they're unique. And the Tubbs case talks about this, Your Honors. It says, a court may look behind a voluntary dismissal at the facts of the litigation to determine whether a party is the prevailing party. Courts must look to the substance of the litigation outcomes, not just procedural maneuvers.
When did the trial court enter the summary judgment as to the contribution claim? because they said that was barred. They entered the summary judgment as to that, and the case proceeded. And then you alleged essentially that y'all had come to an agreement, each party would bear their own costs and fees, and they objected to that, saying there was never such an agreement. And the trial court apparently believed their argument. And then the trial court, and then you voluntarily dismissed all claims. Well, the only pending claim at that point was the indemnification claim, right?
That's correct, Judge. And just to address those issues, there's no agreement memorialized in writing regarding any agreement to walk away.
Right.
And we concede that.
Right.
Mr. Thompson and I had discussions prior to filing our notice of voluntary dismissal regarding a potential walkaway. There were discussions to that effect, but you're right.
As far as I'm concerned, I think we should accept the trial court's determination that, that y'all never had an agreement, that y'all were going to settle everything and everybody pay their own costs and fees. The trial court came to that conclusion, and I think that I would accept that. But so when you voluntarily dismiss, the only remaining count was the count for indemnification.
That is correct, Judge. Sequentially, that is accurate.
So if that's the case and they had prevailed on the motion for summary judgment as to the other count, why aren't they the prevailing party as to that part of the case?
Well, when you look at the circumstances as a whole, they weren't the prevailing party because they've still got the common law indemnification issue out there. And under these circumstances, they're unique, Your Honors. They're kind of the last man standing, as I alluded to before, and we file a notice of voluntary dismissal without prejudice, under the understanding that we would walk away, potentially, even though there's not an agreement memorialized in writing. But we don't feel they're the prevailing party based on these facts.
When you realized that you couldn't walk away without this potential, did you try to withdraw that and then try to pursue your claim?
We filed a notice of withdrawal of the notice of voluntary dismissal.
And so,
once we've determined they were going to attempt to get their fees and costs, we were surprised by that. And so therefore, we attempted to, I guess, put the toothpaste back in the tube, and we tried to do that, Your Honors.
the result of that was?
The result of that was the underlying court struck that notice of withdrawal. That was how they dealt with that. But we were ready to litigate the remaining issue if we had to. But we had the understanding that we would potentially have this walkaway agreement, Judge. So,
If you were within the statute of limitations, just filed a new lawsuit.
I'm sorry, Judge?
I said if you were still within your statute of limitations, I guess you could have filed a new lawsuit.
We could have, Judge, but we did not feel, we wanted our client to, be done with this without disclosing any attorney-client privilege information. We wanted to end this litigation. It was 3 years at much expense. We got a good result for our client. We wanted this to end.
Wasn't the basis of the trial court's striking your attempt to withdraw based on your argument that you had an agreement with opposing counsel that each party would bear their own costs and fees, and they were able to establish that you never had such an agreement? And the trial court said, well, based on that, and that was your basis to withdraw, I'm going to strike it. I mean, they even presented letters indicating that there was never such an agreement, that each party would bear his own costs and fees.
Before those letters, Your Honor, there were discussions between the parties to have a walkaway, and we had walkaways with other parties.
That's why the trial court said, I'm not allowing you to withdraw your notice of voluntary dismissal, because you based it on this argument that we had this agreement that each party bears his own costs and fees, and they were able to establish that you didn't have that agreement.
I think the underlying court, Your Honor, didn't see the notice of withdrawal as procedurally allowable. Okay. I think that was the basis, Your Honor.
Okay.
So again, Your Honors, pursuant to Statute 76879 and the MX case, they're not allowed to recover their attorney's fees and costs under these circumstances. Now, the appellees have cited to several cases that talk about the issue of being entitled to attorney's fees and costs. None of these cases stand for the proposition that they're entitled to recoup their attorney's fees and costs pursuant to 76879. The Thornburg case is a declaratory action that involved an election. The Alhambra case cited by them refers to statute 720.311. It's a homeowner's claim. Further on, the Tunison case that they cite to, in that case, there's an attorney fee provision in a contract. So none of those cases, and appellee has failed to cite to any case that stands for the proposition they're entitled to recoup under 76879.
Well, the trial court entered a final judgment in this case as to the Scott partnership on the 13th day of February on the only remaining count in the complaint, because you had voluntarily dismissed, I believe, on what, the 8th of
That's
February.
correct. That's correct, Your Honor.
And the trial court had entered summary judgment on the contribution claim, and so the only thing left to do at that point was enter a final judgment, which the court did. So on the only remaining claim it could enter final judgment on. So how are they not the prevailing party when the only claim left is the one that the judge entered final judgment on?
We think that entering the final judgment was an error by the trial court, Your Honors, because they cannot be deemed the prevailing party. And the filing of notice of voluntary dismissal without prejudice, we would even argue precludes the court from having jurisdiction to enter a final judgment, actually. If it's dismissed, it's no longer pending. That's part of the appeal, is that we're appealing the final judgment and the award of attorney's fees and costs that's contained within the final judgments, Your Honors.
Your notice of voluntary dismissal wouldn't apply to the contribution count because the trial court had already entered summary judgment as to that.
That's correct, Your Honor.
We're talking about the indemnification count.
Correct, Judge. Correct.
Right.
So to sum up, Your Honor, I think it's also important to look at the nature of awarding attorney's fees and costs. It's punitive in nature. I think Florida case law talks about it should be done only certain circumstances. These are not the circumstances under which attorney's fees and costs should have been granted against my client, Judge. The case law supports this. There's no case law supported by or cited by the appellee that entitles them to attorney's fees and costs pursuant to 76879. Under our case law, the case law talks about the prevailing party issue. You have to look at the facts as a whole, and the court doesn't necessarily have to award costs. I know that's one of the issues Your Honors are concerned with. But to sum up, we don't feel that TSPA is the prevailing party under these circumstances. There was a pending claim against them that was valid, and therefore we feel that this court should reverse the lower court's ruling accordingly. And I would request time at the end to rebut appellee, please. Thank you.
Sir.
May it please the court, Andrew Thompson for Scott Partnership Architecture, the appellees. Sometimes I'll refer to them in the papers as TSPA. The trial court did not abuse its discretion.
Why don't you address, there are cases that say that, and the record indicates that their notice of voluntary dismissal as to the indemnification count was without prejudice, right?
Correct.
Right. Even the Florida Supreme Court has rendered decisions that say that in circumstances like that, because it's without prejudice, there's no adjudication on the merits, and therefore an award of fees under 76879 is improper.
Correct, Your Honor. The Supreme
How is it that you support the trial court's award of fees for the indemnification count when they voluntarily dismissed it without prejudice?
Well, we moved for fees and costs predicated on the final judgment on the contribution claim. The final judgment includes that the contribution.
But I know, but the trial court awarded fees for both counts, right? Defense of both counts, right?
Correct.
Okay, the contribution claim, I'm not talking about that, because summary judgment was entered as to that. Once the summary judgment was entered, they entered a notice of voluntary dismissal of all claims, but the only remaining claim at that point was indemnification.
Correct.
How is it that you're entitled to fees if they voluntarily dismiss without prejudice as to the indemnification count only?
Well, it's a bit of a conceptual adventure because, say in the instance where they were allowed to withdraw that notice of voluntary dismissal and then proceed forward to trial on the common law indemnity count.
Well, they weren't allowed to do that.
But if they were, they would still be in the exact same position because the trial court had already found them negligent and responsible to the first party plaintiffs on numerous different counts, and therefore they wouldn't have been able to even prove the first element of a common law indemnity claim, which is why, obviously, the dismissal came in order, in our view, to avoid an adverse decision against them.
I know, but you, I mean, you have to concede that the case law is clear that a dismissal without prejudice is not an adjudication on the merits, and there are numerous cases that say in situations like that, you're not entitled to fees under 768-79.
I do concede that, and I think that this case is different because we had already received the summary judgment on the other issue.
I know that most of these cases deal with dismissal without prejudice of the entire case, but I don't see any reason why that rationale wouldn't apply to one of several counts.
It might. I fully concede that it might. And further along, the court did not abuse its discretion in finding the TSPA was the prevailing party, because if it looks at this court's decision in the Granoff matter, which I believe authored by Your Honor, discussing what the trial courts and the appellate courts would look to in determining whether somebody is the prevailing party, and it would look on the result obtained. I think Your Honors have already pointed out that the appellants in this matter got zero. Their entire cause of action was predicated on receiving some money or complete indemnity for the actions against them. They got nothing, and the final judgment indicated that the appellees shall go forward hence without day.
You agree that your entitlement to fees, if any, rests on the proposal for settlement?
Correct.
Your proposal for settlement was as to all claims, counterclaims, et cetera. And I guess the concern that I have here is, I mean, they clearly didn't accept that. You clearly prevailed on the, I'm getting confused, one count and not on the contribution and not on the indemnity, because they withdrew that one. But I'm wondering if that, you know, how you perceive that to trigger the offer of judgment or the proposal for settlement, which was predicated upon, you know, settlement of all claims, and as we know, they withdrew one claim.
Right. Well, it's two different arguments, I think, that are trying to be made there with respect to the proposal for settlement's language of offering to settle all claims. That's more of an ambiguity argument as far as we didn't understand the offer, because under the statutory language, it's that the offer should be clear. A qualifying offer should be clear enough for the offeree to understand what is being proposed. And in that instance, it's to settle and end the litigation as a whole, resolve all claims. There is no case law that says we have to then prevail in a specific matter under the language of the statute in order to pursue attorney's fees and costs pursuant to the proposal. In the appellant's papers, they make the argument that, well, if we reversed the order perhaps and dismissed one claim and then we became we were awarded summary judgment, that in a situation like that where there's only one remaining claim, we would be entitled to fees and costs pursuant to the statute. But that doesn't, that's, you know, the time frame. First of all, there's no authority that's presented to support that, and it's just illogical, because in an instance where there is 100 claims or different counts that are brought and 99 of them are dismissed, one is still active and you win on one, you're the prevailing party on the one remaining. Whether you prevailed at the instance and then litigated 99 and they decided we don't have a chance of proving 99, we dismiss them all, you're still back to square one, which is you've won on the remaining count that was actually litigated on the merits and found in favor of the appellees. So I will entertain any other further questions, but this court should affirm the trial court's award of attorney's fees and costs. I would specifically like to point out that there is no argument in the appellant's papers that the proposal for settlement itself is ambiguous, and in fact, in their reply to the appellee's motion for reconsideration, they state quite clearly, we agree that this is...
If there was an issue, they abandoned it in their reply, so that's not an issue anymore, I don't think.
Sure. Okay. And there's also no argument before the court as to the reasonableness or amount of the fees. In fact, there was no challenge presented as to that or whether the offer was made in good faith.
Okay, thanks, Counsel.
Thank you.
Your Honors, I will try to be brief. I just want to reiterate and address some of the points that Mr. Thompson talked about. As this court is aware, proposals for settlement must be construed strictly. This proposal for settlement called for all claims. They did not prevail on all claims. They prevailed on one claim. We dismissed the remaining claim. In our view, that does not trigger a proposal for settlement, which must be construed strictly. Regarding the topic of the court finding my client liable regarding a plaintiff's motion for summary judgment, I think that's wholly irrelevant to this issue. That was not part of the court's ruling in the underlying matter as far as the Scott Partnerships issue. So we would again reiterate, given the context of this case, this complex litigation case, the Scott Partnership was in essence the last man standing of 50-some-odd subcontractors, and my client wished to cease litigation. Given these facts and circumstances, which this court is allowed to look at specifically, they cannot be deemed the prevailing party, and doing so is punitive in nature and be a harsh sanction against my client. And on a personal note, I'd like to thank this court for continuing the previous hearing we had. I had a family issue, but I appreciate that consideration.
Our pleasure. Thank you so much. All right, thank you both. That will conclude our arguments for the day. Have a safe trip home.